Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This police unit is trying to box him in, but instead he just crashes into the tree, and away he goes. But let me widen out. I don't know how far this will take him. Yeah, he's basically cornered. Wow, look at this. Off the road and onto the freeway. Oh my gosh. So he is on the freeway, going wrong side of the road here on the 91 freeway, going eastbound in the westbound lane. This car is smoking. I pray to God that the vehicles that are coming in his direction see this car coming at them and they're able to stop.
All right, good morning, or good afternoon it is. Good afternoon, I'm sorry. I'm falling behind on my time a little bit. Good afternoon. Welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome back this afternoon as we're surfing the world of true crime to see what is new and happening. I think we're going to check out Judge Shackelford's courtroom here in just a second. So we're going to do that as we jump back and get started again. Had a lot of you actually reach out to me about a couple different cases. Kiss and Tell, from what I've heard. Cover the kids' ears. Contains a lot of adult fetish material. So unless you are interested in that, don't go there. Don't go there. So we're not covering that one. Yeah, it's Kiss and Murder. Oh yeah, that's the one. Yeah, it's whew. Yeah, the YouTube would zoink us right away on that one. Anyway, we've got some other stuff to go to, so that's gonna be good anyway. So we're gonna jump to Judge Shackelford, her trial or her courtroom in just 1 second. I think she's actually talking right now. Let's weigh in and see.
This is 250385FY, the People versus Sarah Ford.
Third Ross on the information.
Good afternoon, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Sarah Ford, who stands to my right. Ms. Ford, state your name.
Sarah Ford.
Sarah Ford?
Ms. Ford want to go to jail?
No, Judge.
It seems like she might. All right, you're here today because there's an allegation that you're on bond. I gave you a bond, and the conditions of your bond were that you not do drugs and you were subject to testing. So there's an allegation here that you tested positive for cocaine on a drug test on 9/8, and that you admitted to using cocaine on 9/6. Do you understand the allegation?
Yes, I do.
And you understand if you plead guilty or I find you guilty of this, I could modify your bond. I could add more money to your bond. I could revoke your bond. I could give you jail time. Do you understand that? Don't cry now.
I know, I'm
you should
sorry.
have been crying on September 6th when you're coking it up.
Believe me, I did.
Don't cry now. So do you understand that? Do you understand what I said?
Yes, I do.
Okay. Ms. Segura, how are we proceeding?
Judge, so obviously I think the test speaks for itself.
All right. Well, let me ask you this. As to arraignment on the violation.
We waive formal reading of the violation and stand mute.
Darian, welcome.
All right. So I've entered a
Or
not
Marion.
guilty plea for
Defendant Marion
purposes
Wilford.
of that.
Now what? Gorgeous Jessica, congratulations on 17 months. Thank you so much.
Kara, do we have her on bond doing any sort of treatment?
No.
Kim would like a little
Judge, I
recognition.
don't know if
Congratulations, Kim. You did
from
effectively
defense
under
on
it.
this.
I'm gonna, Ms. Segura, let me say this before I hear from defense. If
Yes.
you want to enter a plea on this and waive the hearing, I want you to understand that if she is asking you to say something like she kissed someone who did coke, or she had sex with someone who did coke, or she smoked some weed and there was accidentally coke in it, if any of those sort of things are on the excuse that you're going to give for her use, I want you to be aware that I'm incredibly intolerant to nonsense today, and I have very little patience for nonsense. So I want to say that. So I can set a bond and we can have a hearing on it later this week, or I can take a plea now on it, but like, I'm not going to entertain garbage.
Judge, I guess prior to entering a plea, if we do that, Judge, what is the inclination of the court as far as sentencing goes? Because I did.
Well, for the violation, I mean, my concern is Ms. Ford has a drug problem, because Ms. Ford doesn't have a criminal history that I can see a significant criminal history, and she's on probation in a court where she knows I could revoke her bond and put her in county, and she got the benefit of this plea, right? No early discharge, 18 months, like this is the plea offer that we haven't sentenced her on. And she needs help, she needs treatment. But I mean, like, if we give her an option, so Ms. Grasso, we haven't sentenced her yet, so we haven't had her start anything because she's not been sentenced.
Correct. She, today was her second scheduled PSI because she did not appear to the first one due to reported car troubles. She was an hour late today, so I did not have time to do her PSI. And when she showed up, that's when I tested her. She was positive and she admitted to using. So I haven't even had time to get any sort of history from her at all.
I mean, I could amend her bond conditions to have her on the phone with DWIN to get her an IOP if she qualifies, which she will, based on the fact she's actively using cocaine while on bond on a felony that's been reduced to a misdemeanor. So I can give her some treatment requirements and modify her bond to do that. Or I can just revoke her bond. I mean, I'm inclined to give her an opportunity to take advantage of resources that we would normally have given her at sentencing, but I can just make it a bond condition now.
We could, if her address on the file is correct, she's quite a ways away from this court, so we would have to get on the phone with you and find resources up here for her.
Where do you live?
Up Claire. Claire, about 3 hours away.
14 margin.
You should have finding a place down here though.
What's that?
So I'm in the middle of trying to find a place down here.
Well, I mean, you need to get into outpatient treatment, whatever level of care they need, because you're grown up. You look like an adult and you're doing coke while you're on vacation. At least that's the allegation. So, I mean, I'm inclined, Ms. Segura, I guess the longest answer you've ever had, I'm inclined to give her some treatment provisions as additional bond conditions. But if she continues to not appear or to test positive, if she can't comply with bond, then I'm just going to give her a cash bond. She can go to county.
So, Judge, with that in mind, and I believe we are going to plead now, plead guilty to the violation, and hopes of getting her into outpatient treatment.
Yeah, I would.
Yes.
I don't see a seatbelt on Marion Williford.
I need you to go over these rights with her, Ms. Segura, before I get the plea. I thought I had one in the file, but I don't. If you could just take a second to go over hearing rights with her.
Yep. Do you want us to step out, Judge, and do it?
If you can, then we'll just come back in and take the plea and we'll get some additional conditions.
Okay, we can do that.
All right, do I have anyone ready? Do we have anyone ready on anything?
All
right, Mr. Williford, you talk to the lawyer now.
Yes, I have.
Perfect. Ms. Bates, I'm just waiting for Mr. Gazicki to come back in. What do you have, officer? Oh, you're on Williams? Okay.
Ms. Bates is back. Mr. Williford's ready.
Is that Williams?
Yeah.
Yeah, let's go.
Yeah, because we're just waiting on Nora.
Is she here?
Yeah, she's here.
Oh.
We went and got her, said we were ready on Williams, and she said, well, I'm ready too, but it's going to be a minute before I get
I'm going to be up here so we don't get in somebody's way. All right. Let's give him a second to get going. Apparently, Judge Shackelford doesn't mind you wearing a hat in court or driving around without your seatbelt on. So we've got that going on. Miss Bates was here briefly, and now we're admiring the, what is that on the ceiling? Is that a popcorn ceiling? Not a big fan. Tough to paint. Fix it.
I wanted to stop the account using your Microsoft account.
No. I don't know which one it is. Here's Miss Bates.
All right, Williford and Bates, as soon as the attorney comes in, I'll call your cases and get you moving. I just am waiting for all the parties.
Yes, ma'am. Thank you.
Thank you. All right, 1 second. So this is last name Williams, Jamie Williams. Do I have that file or do you have that file down there? Jamie Williams. All right, we're on record. This is...
She's not putting up with any crap.
252469 FY, the state of Michigan versus Jamie Williams.
Good afternoon, Your Honor.
Judge Neighborhood Defender Service, Michael Leno, PA 3424, Ping on Mr. Williams. Mr. Williams, please say your name.
Jamie Allen Williams, Your Honor.
All right, so it's time and date set for the preliminary exam. Mr. O, I know you indicated briefly that you had to make a record or that there was some sort of issue before we started the exam. Can you go ahead and make a record on that?
Yes, Judge. There is the normal outstanding discovery issues, which are I have a 13-page police report, 10 pages of which are pro forma templates. There's only 3 pages that are relevant to the officer's police summary and the witness's hearsay statement, which is a paragraph long. We also don't have body cam footage from this case capturing the arrest of Mr. Williams. And I just discovered this morning that there were 2 additional reports submitted by the Taylor Police Department, both of which were denied for insufficient evidence, which makes them discoverable under U.S. Brady versus Maryland. Any evidence that could be favorable to the defense or could be used as impeachment that bears on the credibility of their main witness is under the umbrella of Brady.
Are they from this same instance or 2 other cases that were previously submitted under different fact patterns on different dates?
Different dates.
Different dates, different fact patterns.
Same witness.
Same complainant.
They were denied. They were prior to this incident. And then as for the body cam was shared. I did share the body cam for the day of the arrest. I was notified yesterday by Mr. O that it looked like the body cam was leading up to the arrest, but not the full arrest, in which I contacted the officer in charge, and I believe he was going to go check on that. But
Officer?
the body cam for the...
So the case in question that predates this one.
No, I don't want to talk about that. I want to know what is their body cam. So what Miss Louise just indicated is there's body cam that was submitted and produced that is prior to arrest, correct?
That's my understanding from Mr. O's email.
Okay, so you don't actually have the arrest or any of that.
That's correct, Judge.
This case was a front desk report, Your Honor. There is no body worn camera or any digital evidence that I'm able to provide to the prosecutor. The case that they're requesting body cam from is not my case. And evidence.com was generated, but I did it for another detective, and it must not have the entire incident. It's for a separate case, not this case.
The case that wasn't signed.
Correct.
Which is still discoverable under Brady. And I am entitled to those reports, and I'm entitled to those body cams.
Do you have any case law that says he isn't?
I mean, it's discovery is pending. It doesn't have to do with this case.
No, I understand that. But what you're saying, how did he get in custody on this incident?
Your Honor, so when I was working on this, when I requested the arrest body cam for this incident, I thought I was requesting for this incident. Apparently it was separate. I didn't know that there were 2 different ones. I did deny the ones, but I didn't make a connection.
Okay, so what I'm asking though is on this case, someone walks into the police department, I'll presume it's the complainant, and she makes a report, right? And then somehow, so a charge is brought by the prosecutor's office, and somehow the defendant, Mr. Williams, is in Greens in custody. Was he arrested? Did he turn himself in? Corporal Johnston.
My assumption, Your Honor, is that the last report that I saw, which was the case that was denied, is when he was taken into custody for the felony warrant that was also issued from this case.
What are we drinking? Is that at Arizona?
So there is arrest video.
I believe so.
But he may have been taken into custody based on another case, but that was the arrest that also applied to this case.
Correct.
So he's absolutely entitled to that, hands down, right? It's this case. Even if he's arrested on something else, if he's being held because these charges were brought, that video that's discoverable. There's no doubt in my mind.
And I understand, Your Honor, I would agree. It's just that I was just notified yesterday about the arrest body cam, and we also just found out today how that whole arrest happened and that there was a pending felony, but he was arrested on a different matter.
Okay.
I do have the complaining witness, and we are ready to proceed.
Okay, I mean, Mr. O, look, discovery's ongoing. I understand that they've provided some. You're certainly, I mean, from my perspective, I think that there's at least legitimate arguments that can be made on your behalf, I mean, on your client's behalf, that those other prior reports go to bias or witness credibility or some other issue that would make them discoverable under Brady. Right? I mean, do you have anything that tells me they're not?
I don't have anything that tells me they're not, and I'd be willing to provide whatever discovery.
Okay, so there are prior reports of prior statements that the complaining witness has made regarding other allegations similar to these, correct?
That's correct, Judge.
Correct.
And those weren't.
So is your argument then that you need those reports to proceed to exam?
That's 100% my argument, Judge.
I believe this is the first incident for this matter, Your Honor, this case that we have today.
So this is incident number one?
Correct.
And the other two are incidents that happened after this incident?
Correct.
Before he was taken into custody?
Correct. Before or during being taken into custody. I'd have to look at the computer to confirm.
Have we arrived yet, Mr. Williford?
But I recall them being after this case.
So this one was 5/9/25.
Again, Your Honor, all of this was.
When are the other two offenses alleged to occur? If they were before or contemporaneous, I mean, there's no doubt you should have a right to have them for exam. But if they both, from my perspective, but if they both occurred after, I mean, is that somehow affecting your ability to effectively cross-examine a witness when the incident at hand, neither of those incidents had occurred yet?
It is, Judge, and the response is there's no temporal requirement under the Brady analysis in the timing of the allegations, because from the defense perspective, it's a series of escalating allegations that ultimately land Mr. Williams in custody, because the May 9th allegation wasn't enough. He was still out roaming free, and she makes subsequent allegations to further her goal. And then that goal is accomplished, because my understanding is the arrest happens after the third allegation. The second and third of which were denied by the prosecutor handling this case for insufficient evidence. And that's the key point of the argument. There is a credibility determination being made as to her allegations. It's the same witness for all three cases, and I'm entitled to that material to effectively prepare for the preliminary examination, to question her about those incidents, and impeach her if necessary.
Sounds fair.
Your Honor, to clarify, so this incident date is like May 9th, 2025. We have the first one from April 24th, 2025. And the second report from May 14th, 2025.
Why is he smelling his fingers?
So one happened prior, one happened after.
Which makes it worse.
I mean, it makes them more relevant. Right? I mean, he's got a right to effectively cross-examine a witness even at a probable cause hearing. And how is he able to do that if he doesn't have an opportunity to review any statements that may or may not be statements he can use for impeachment purposes? I mean, that's just the reality of the case.
And I don't disagree. I think this was just an oversight that I had probably assumed that they were prior, and I thought this one was sooner because it had been referred around August. Or charged around August.
Will the court entertain motion from defense?
I mean, I'm not gonna, no. I mean, you can make your motion, make your record, Mr. O. Of course you have, whether or not I'm entertaining it, doesn't matter, make your record.
I think the most prudent thing to do would be to dismiss, and the prosecutors can refile once they get their ducks in a row. Mr. Williams is being prejudiced by the fact that the delay is on the prosecutor and he's in custody.
I would request an adjournment. I can provide the discovery without having to reissue a warrant. I think it would be inefficient to do so.
I mean, here's the thing. I respect your position, Mr. O, but I'm going to, if I dismiss it, it's going to be without prejudice. Mr. Louis is going to run back and reissue before he's released. And then we're really resetting the clock because then he's going to have to be rearranged and then he's got another 21 days. I mean, so I feel like I'm setting your client back more by a dismissal because that's what's going to happen. Does that sound accurate, Ms. Louis?
Yes, Your Honor.
I mean, and now we're resetting a clock instead of just pushing this out a week, we're pushing it out potentially 3 weeks. So, I mean, I guess that's my thought process. I am happy to sign a discovery order. Mr. O, if you get to me exactly what it is you want, and I mean, on the record, I acknowledge there's body cam footage. The body cam footage of the arrest, whether or not it had to do particularly with this offense, any warrant requests that were submitted, any police reports from these other events, he's entitled to that as a matter of law. So that all needs to be handed over. Is there anything I didn't say?
No, Judge, but I will include anything the court may have missed in a written discovery order that I send to the court.
Okay. I mean, if these are the 3 things I'm granting, I shouldn't have to sign an order because Ms. Louis should just get them to you. I'm happy to do so. But those 3 things, and if there's something additional, make sure in your order that you indicate why it wasn't placed on the record today, unless it's completely contemporaneous with all of these things that we're discussing, police reports, investigators reports, and body cam footage from these incidents.
Understood.
I mean, and I'm not so concerned, honestly, I'm not so concerned with the body cam and you know, what that will or won't provide you at an exam, but certainly I think you have a right to effectively cross-examine a witness. And if there are all these other police reports or statements that may or may not be, I mean, I don't know. I don't know if they're consistent or inconsistent. And I guess that's the issue. You have a right to know that. So that's what I'm most concerned about for purposes of an exam is police reports, witness statements, and investigators' reports. So, okay, let's figure it out.
So to respect the court's ruling on the motion to dismiss, would the court entertain the bond motion given the circumstances?
Here's why I won't, Mr. O, and I will after I hear evidence in 1 week. My concern is when I look at someone with a criminal history that they're low-level offenses, but there are, I have concerns about assault and batteries. I mean, there's a history of assaultive behavior, including prior domestic violence conviction, and I'm not inclined. I see that there's some other, were you born in March of '92?
Yes, ma'am.
I mean, I just have some other concerns. I'd feel much more confident, and I will absolutely entertain a bond motion at the exam once I hear evidence, but I'm not comfortable doing it just with the history and the nature of the allegations, which are just allegations, but I prefer to hear some testimony before making a bond reduction. So let's look at I mean, next Monday, we'll figure it out, but we have so many exams next Monday, it's getting scary.
I'm actually not available next Monday. Next Monday, I'm available the 22nd.
Your Honor, I believe you have a really busy day on Monday.
Monday's bad. Monday the 15th makes me want to, like, it's very bad.
I can do the 22nd.
All right, 11:30.
That
Yes,
works
Judge.
for me as well.
Yes.
We've got another spicy one lined up after this.
9:22 at, what did I say?
11:30.
All right, I'm gonna say 11, so everyone actually shows up and we can start, okay?
Your Honor,
She doesn't
sorry
trust him
about
to be
you.
on time.
There are alleged contact violations, if it's possible.
How? Tell me all about it.
She has
Give us the
advised that
tea.
she's been receiving jail calls from the defendant.
From the jail?
Phone privileges revoked.
Miss Louie, you know this is the easiest thing to discern, right? There's an individual at the Wayne County Prosecutor's Office. His name is Brian White. You ask Brian White or whoever's at the jail, Kai Sobel, I'm not sure who it is. You request jail calls to a specific phone number, they'll get them to you. If you discern or learn after doing your due diligence that the defendant has in fact contacted the complainant from the jail, you bring it to my attention at the exam date or prior. You make sure Mr. O is notified, and I will suspend your jail calls. They will put you into PC, and you will sit in a little tiny area. Don't say anything. Listen to your lawyer. I'm telling you what I will do. If I find out that you are calling the complainant from the jail, I want you to understand it's the stupidest phone call you've ever made. If you made it, which I'm not saying you did, because I said you're not allowed to talk to him. All county jail calls start with something like this, sir. This call is being monitored. This call is being recorded. And not only that, but the phone call system at the jail, they can literally type in a number, and even if you use someone else's account because you think you're smart, they'll pull up every call from the Wayne County Jail that's ever been made to that phone number. And then they'll find out if you're on the pod with the dude who made that call. It's not rocket science. It's something that takes a sheriff maybe 10 minutes. And then she files a motion. I get rid of all your jail calls and say you can only talk to your lawyer. The only calls, and then you're going to languish in the Wayne County Jail with no calls to mommy or your grandma because you made phone calls in violation of my court order. Does everyone understand what I'm saying? Are we good?
Yeah, we're good. We're
all
good,
right.
Judge.
Don't do it. If you did it, don't do it again. If you did it, I want to know. And let me know and give me something and we'll have a hearing on that. But I'm saying outstanding disco, other PD reports, investigator reports, statements, body cam, to be produced forthwith. And I'm just making a note that there's an allegation, there was a bond violation, and we'll hear more on that as soon as you do your due diligence.
I will, thank you.
All right, we're all set. Thank you.
We also ordered a DSC report.
Let's see if
Yes.
Mr. Williford's ready.
Yes, I'll get you a DSU.
That was a bold move, asking for the case to be dismissed until the prosecution gets their ducks in a row. It was just peacocking for the client, I think. That wasn't going to happen. All right. Next.
All right. We've got Amani Bates here.
Ma'am, turn on your
Ms.
camera.
Bates, are you ready? This is 251561, the People versus Amani Bates.
Morning. Good afternoon, Your Honor. James Gazicki on behalf of Ms. Bates.
He just woke up. Give him a minute.
She's going to enter a plea of guilty to a plea of no contest to the reduced charge of assault and battery, which will be taken under 771.1 and with the conditions that are in the plea agreement and those set by the court.
All right, Ms. Bates, is that accurate?
Yes, ma'am.
Ms. Bates, you understand that assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. That's a statutory maximum. Do you understand that?
Yes, delayed sentencing.
Okay. And did you have a chance to go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes.
Did you understand your rights?
Yes.
And did you give your attorney permission to sign and date this form?
Yes.
Ms. Bates, you understand that if you enter a plea of guilty, you'll be waiving the rights listed in that form. There will be no trial of any kind.
No trial.
Yes, ma'am.
You understand if you're on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
Yes, ma'am.
You understand that if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
Yes, ma'am.
So ma'am, this plea is being offered to you as a delayed sentence under 771.1 for a period of 12 months. Because it's under 771.1 and because it's an assaultive crime, you will not be eligible for early termination from your probation. You will do a full 12 months of probation. Do you understand that?
Yeah.
Okay, and there's an agreement that you'll have no contact. These are some of the terms of your probation. You'll have no contact with Alexandra Sanders. It looks like we're going to set a hearing for restitution. You'll attend batterers counseling and anger management or batterers counseling, whichever one the probation department deems appropriate. Do you understand that?
Yes.
Okay, and do we have a complainant here on this?
There was one, I don't know where she went.
Yeah, the prosecutor may have let her go. I'm just gonna double, triple check.
Yeah.
All right, Ms. Page, you understand all that?
Yes, ma'am.
Okay, and knowing all of that, how do you plead the reduced charge of assault and battery?
No contest.
Guilty.
No contact.
No
No
contest.
contact. No contact.
No contest. Not no contact.
Or what's the basis of the no contest plea?
Civil liability.
I love when they screw up their one
Civil
job.
liability, Your Honor.
You got one job.
All right, is there ma'am, has anyone forced you, threatened you, or promised you in anything in any way to get you to enter this plea?
No.
Are you pleading guilty of your own free will?
Yes, ma'am.
I'm sorry, pleading no contest. Mr. Kazicki, is there a stipulation for me to review the police report to establish a factual basis?
Yes, Your Honor.
Now, all three of them have said guilty instead of no contest. She had contact. That's why she's charged with what she's charged with. I want to see Mr. Williford come back and with the purple coconut hat and see what's going on in his case. Now that he's arrived at his destination, taken on a bit of a home tour, and then the signal dropped out. Judge is reading basically the police report of what happened. Should just take a minute for her to get the gist of it. Judicial assistant trying to peek over her shoulder, get some of the juicy details, but can't quite read from there. During lunch, instead of eating, I had to hack into my son's computer because he changed the password. Had my wife enter a new password because he's going to leave that computer behind when he goes to school. Changed the password, and then my wife tried to log in. The password didn't work, and it's the only admin account. So we had to do a bit of with Windows. It's a little difficult. You have to do some backdoor access into safe mode to activate.
All right, the police report certainly establishes
account.
a factual basis, so I'll accept the no contest plea. Ma'am, you're going to be referred to the probation department for a pre-sentence investigation. They'll contact you, Ms. Page. You'll receive notice within 7 to 10 days. If you don't receive notice, call the probation department to ensure that you don't miss your court date. You understand?
Yes, ma'am.
They'll do an interview with you. They'll make a determination as to what an appropriate sentence is. And there may be additional terms aside from these 3 that were laid out as part of the sentencing agreement. Do you understand that?
Yes, ma'am.
So if you don't hear from them within 7 to 10 days, what do?
Reach out to them.
That's right. Reach out to the probation department. Your bond conditions continue, and we'll see you back at your sentencing date, okay?
Yes, ma'am. How do I get the probation number? Do I call the jail?
If you could just call the 23rd District Court and ask for probation.
Okay.
If you type in 23rd District Court online, there will be a list of numbers and you should be able to contact probation directly. And if not, just call the general line and they'll get you there, okay?
Okay.
All right, you're all set. All right, are we ready on?
Williford.
Mr. Williford is back. Mr. Gazicki, did you talk to Mr. Williford?
Yes, I did, Your Honor. This matter is scheduled for trial on the 19th. We're going to proceed to the jury trial.
Oh,
okay. All right, let me bring out the complainant as well, just so it's all, everyone's here.
I don't think she's.
She is. She's still in a breakout room.
I know, but she's not. I'm trying to get her out. She's not.
All right, she's in a breakout room and she's not responsive. So I don't know if she's actually still in the breakout room. Miss Dennis, can you check with the complainant on this case?
I sure will, Your Honor.
All right,
I had told her to hold on.
Yeah, Miss Maudlin's been trying to bring her out and can't.
Okay, I'll go and see if she'll speak, if I speak to her.
All right, well, she doesn't even need to speak. Just let her know that we're proceeding to jury trial next Friday, 9/19 at 9 a.m. in person.
It's a lot of nines.
Okay, I'll tell her that. Thank you, Your Honor.
All right, great, thank you.
What does that have?
All right, Ms.
Honestly,
Williford, bond continues to see you back on that day.
does the hat say
All
what?
right,
Guilty on it?
Yep, where's Miss Ford's file? Sarah, come on back up.
Okay.
All right, oh, I need Miss Grasso.
Oh, we want to hear the end of this
On
one.
that, we'll do Mr. Bentley.
Or
We'll
should we
wait
jump
for Miss
now?
Grasso.
Should we jump now?
Ms. Ford, if you could just have a seat for a second, okay? We gotta get the probation department back up here. This is 25243 AFY.
We're gonna jump. We're gonna jump because there's only so much high treble I can take in one day, and unfortunately, Miss Shackelford's court is in that register. All right, so we are going to go to Judge Kristen Simmons' courtroom. Here we go. Let's jump down there.
No.
Not on this record, Your Honor. Thank you.
Thank you. We have jury instructions for this case.
Josh says this one's spicy.
Yes, Justin, only I have filed trial documents.
And the people acknowledge the failure and apologize to the court and will not object to the defense's proposed instructions.
Hang on.
Oh,
I've got a prank call. Hello?
Hello.
Hello?
Good afternoon. My name is Juniper. I'm calling because Medicare recently launched inflation relief package in the state of Utah that can provide extra support for daily expenses such as groceries, gas, and prescriptions. So do you have Medicare Part A and B, right?
Can it pay for vacations? Hello?
Hey, can you hear me?
Can it pay for vacations?
To see which added benefits you qualify for, are you enrolled in Medicare Parts A and B?
I was asking about a vacation. Is this a real person or a computer? Hello?
Hey, can you hear me?
No, I need someone else to come on the line, please. Ah, bummer. I trying to get through the computer. Sometimes you can get to a real person if you push hard enough. All right, let's jump back to where we were and continue. Oh, I have to go. Actually, we've got to go all the way up to 41. It's a good thing I checked that because that would have been really bad. We've got a little bit of spice happening here. 41, 45 is when it's going to happen. Okay, here we go.
For the record, in the matter of the City of Lansing versus Travis Young, 2401233341, appearance, please. I'm sorry. Your name for the record, please, sir.
Travis Young.
Okay, Mr. Young, you owe $198 on a disobeyed traffic sign. When are you gonna pay?
Well,
Every time we start off with the well, it gets tricky.
Okay. Well, so back when I started,
There's a lot of like. I had a very specific question. When are you gonna pay?
I can pay something next. Probably in like 2-3 weeks. How much? I could probably put like 100 maybe.
Okay, you're working?
Uber.
You got a car?
Yes, I do.
Oh, okay.
It ain't gonna be the same thing. I have my insurance. I have everything.
You drive Uber.
Yes.
Okay, and so you're gonna pay $100 by when?
Next, give me. I need about 3.
I'll give you 30 days.
All right.
To pay $100.
Okay.
And you'll pay the balance within 60 days.
All right. Oh, okay. So I only got this.
I didn't even ask.
Right.
I don't even, because it doesn't matter to me how you got it.
But what I'm saying is, I never got a court date on this.
You got the ticket in your hand?
That's all I got is this. And I never got a court date.
Appearance date, on or before 3 to 14 days.
Right.
You see that on your ticket?
On this one?
Yes.
Like this thing. This is the something they sent me in the mail.
No, you had a ticket. You got the ticket on November 28th.
Right, 28th.
2024.
And when I got that ticket, they did not send me the letter for the court. They did not send me the letter for the court.
What letter for the court?
For me to come to court, because I took it to court. I took that to court, and I did not get a letter
You took
at
what to
all.
court?
The ticket.
Good enough. You didn't appear in court. That's how you got it default.
Right. They did not send me the letter to tell me what day it was.
How did you take something to court? Did you come up and request a hearing date?
Yes, I did.
When?
I called up and I requested it.
That's not how this works. When did you come up and request a hearing?
I called the number that they said call. I called the number. I talked to the lady. The lady said, you don't have to come in. She said, I can set it up for you right now. And she set it up for me. They did not send me no letter. All I got was a letter talking about I owed you guys $160.
It says here on December 16th, you denied responsibility. It was set for a hearing with the magistrate, Magistrate Milmore.
And I did not receive it.
Well, it was supposed to be, you were supposed to appear on the 2nd of January. You didn't appear. And so here we are in September. Way too far for me to even remove a default.
Oh, see, I even
you gotta pay it. So that's why I said how we got here doesn't matter anymore because we're beyond the time frame for me to return around.
I try to take care of it, and they sent me away.
I don't know who sent you away.
They sent me away talking about
who sent you away. Tell me their name.
The front desk man.
The front desk
man. The dude
at
at the front desk.
The dude at the front desk.
Yes.
Who's the dude at the front desk?
I don't know his name.
Okay.
The guy at the front desk.
The guy at what front desk?
The clerk right here.
Okay, so that's not a front desk.
Well,
this is the court. At the clerk,
the
someone in the clerk's office, the criminal clerk's office, you said sent you away?
Right here, yes.
Okay, but you met with the magistrate, it says.
No, I never met with nobody.
Let me just tell you the record here. You denied responsibility.
Huh?
Whose initials is CHA?
Wisconsin.
Okay, the clerk's office put that you denied responsibility, meaning you wanted to take it to a hearing. Is what you're just saying?
Right, yes.
Yes. On the 16th of December. It's September.
I know, and I've been wondering what's been going on.
Oh, so you're sitting at home wondering.
All I got was a letter that said, I owe you guys $160.
When did you get that letter?
Somewhere around February or so. Was it close around February?
Oh, and you just now came in?
No, I came in. I wish I had the letter that I had came down
and when
here.
You came in,
because I came down here and talked to the clerk down here. And they were trying to make me pay a bond to, it was $160. I had to pay a bond to even see you again. They told me I had to pay a $160 bond to see you.
A bond for what?
A bond to bond it over.
Did you have another? Does he have another matter?
He did. On this one.
You got. I don't understand. A bond for what?
It was. I don't know. It was a payment with Cody.
Okay. Pause. Got another call. Hello. Hello. Dang it. What am I doing wrong?
What is the date on that? Because the register action they put in here is from
the date
December.
On that one was February 3rd. Monetary transaction, payment, cash and case closed. Not sure. Did they give it?
Void receipt. Yes, a void receipt minus 165. So I see where it says payments expense, and then they voided it. So what does that mean?
So what it, you gotta ask Cody.
Can you print that, please?
Yeah.
It is Marquita.
Yeah, I'm grabbing. I'm fine just dealing with it. If I knew I was in default and I would waste your time, Honor. I would just do what we got to do, and I'll be out that door and be at home. But honestly, I never got a chance to even come to approach you guys and talk about that matter in the first place. They didn't even send me a letter. I waited. I take care of all these problems.
Thank you.
And I need my license for work.
Sir.
You might be winning. Just be quiet. Let's see. She's reading the paperwork. They do. They call a bunch of numbers, and then when they get a live one, they take it. But the machine keeps calling numbers. Maybe it was a bump. I feel bumped. Okay, now we've got the court clerk coming down explaining what happened. Did you screw up? I think there's sound, we're just not hearing it. Judges muted their mic because they might be discussing something that makes the court look bad here. Now he's happy. Wait for it.
And it was mailed, it would have been mailed to this address.
Thank you. What's your address?
7526.
Whoa. Man.
It was mailed on December 18th, 2024.
For the first hearing?
For the second hearing. You had an informal hearing with the magistrate on the 18th.
I've never been down here at all.
You had to have request a formal hearing.
No, I have not been down here at all to talk to anybody. I called the lady. The lady said
You called and requested an informal
You
hearing.
called and requested a formal hearing.
Yes.
This is right here on the 16th. So she scheduled it 2 days later. And then it was scheduled for January 2nd.
Where did you say you called?
No, we don't have it that they called. They can come in, they can call, they can send a letter. It's just he denied responsibility separate and formal.
Yeah, I know. I told him about. I saw that he denied responsibility on the 16th.
Yeah, and
so
then
it
we
was set
scheduled-
for a hearing 2 days after you called.
Right. So therefore, she told me 2 to 3 weeks I will be finding out.
Yeah, listen, and don't talk.
Okay.
You called on the 16th of December, 2024. On the 18th of December, notices were generated and mailed to the address that we have, which you said is still your address.
Yes, it did not show up. I got this one, but I didn't get that one. I didn't get the most important one.
But you didn't call and find out what happened to it. If your mail gets lost, you can't decide it's our problem.
No.
I said listen, and don't talk over me. It was generated and sent to you, this is the file. When mail comes back to us, because it wasn't delivered, it gets attached. There's nothing here indicating that your mail came back. So that means it was sent out and delivered to the address that was on file. Your date was scheduled for the 2nd of January. You were told, because you just said it on my record, that it'll be 2 to 3 weeks before you were going to have a hearing. When 2 to 3 weeks came and you didn't have a hearing date, you should have been on the next thing smoking into this building to find out when was my hearing date, because I didn't receive notice of it. You did not do that, sir. The next time we heard from you was after you received the notice of default, which was mailed the same way we mailed the notice for you to appear in court. That was in February of 2025. And so you came and he told you it was Jonathan Jonathan Cody at the desk that you called the front desk. He told you that you had to post a bond in order to reopen the case.
Yes.
And he looks like he tried to put it on there, and that's what I called him for, because I saw where it was taken back off and they voided the receipt. I just wanted to confirm that you hadn't paid anything, and you didn't pay anything.
Right. You're right. I didn't pay anything.
And so since then, and then you did it. So then you didn't reopen the case because you didn't post the bond. And then on top of that, now a late fee gets added because you didn't do anything. You could have came then if you had posted the bond. It would have been reopened. And then you could have requested to have the default set aside. You didn't do that. So now you have to pay it.
I can't say nothing about what you just said.
You can't get a ticket and then make it the court's responsibility when you didn't get your mail. Because the court's responsibility after you request a hearing is to send you notice of said hearing, which this is not a system where we're going and put in a note. Once that hearing was generated, it automatically put a note in the system. Hearing notice generated. And so it was sent to the address we have on file. It did not come back non-deliverable.
What if it could have got lost?
That's not the court's responsibility.
I'm just saying, I'm not saying it got lost at my house. I'm just saying, what if it did not come at all?
It's still not the court's responsibility. This still is not our responsibility. Right. It is your responsibility to keep up with your legal matters. If you have a ticket and you know that you're supposed to get a hearing within 2 to 3 weeks, and 2 to 3 weeks come and go and you don't get a hearing, it's your responsibility to find out where the notice went. I didn't receive a notice. Was I supposed to have a hearing? And if you had a call before the 2nd of January, they would have told you, yes, you have a hearing, and you should have received a notice, and your hearing is on the 2nd. If you had a call shortly after that, they would have said, you just missed your hearing, you were supposed to be here on the 2nd. And then you would have been able to address it and have it set aside. You can't now appear in court in September and want to go back in time and tell me that you never received the mail. At this point, you have to pay it, and we just talked about your payment plan. You're going to pay $100 within 30 days and then 60 days to pay the balance. Okay, so in the future, when you're told it's going to take about 2 weeks, 3 weeks is a little extra. If you set a civil matter, a traffic matter for a hearing, within 2 weeks, if you haven't received the notice, you call the court and find out what your date is. Right. You don't sit around twiddling your thumbs. You'll get a default.
Right. Yes, ma'am.
And then you're responsible. You understand that?
Yeah.
Okay, you're all set.
This is a right, Justin. Put him in the life.
Thank you. Did you let Susan know?
Oh, I'm letting her right. Sorry.
So now we know if you get a ticket and you don't get the letter in the mail.
So we have witnesses here.
Call the court.
On James' matter.
Yes, sir.
Okay. We need jury instructions. Like Friday of last week.
Yes, sir.
And then Mr. Gates, when his attorney comes back, she can be advised that he can be excused. We'll get him a new date though when she comes back.
Want to see how this Ingram guy,
Mr. Washington,
handled things.
Sorry?
No, she's out the hall now.
Ingram jail. How you doing? Post 1, visit 8.
Back on the record in the matter of the state of Michigan versus Tremonte Gates.
Thank you, Your Honor. Can I speak to you, people?
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Gates, who's approaching council table now.
Okay, Mr. Gates is ready to proceed to trial, but we have a priority case going before him, so this matter needs to be reset for trial. That also gives the defense time to go over any of the evidence that was tendered late on Friday, and then the prosecution needs to properly subpoena the third-party witness.
Thank you, Your Honor.
Thank you. Let me get a hearing date, trial date.
We can do September 22nd.
September 22nd at 8 a.m. in person for trial.
Your Honor, my apologies. I'm not going to be present in the office that day. My mother is having surgery.
Okay, we'll do another date.
Thank you.
I think we're going to jump on this one. We're going to bail. Now that we know not to ignore our tickets in court. Let's see what we had. Shackelford. I can only handle a little bit of her every day, but. Some stuff out of Fulton. Pardon hearings. We haven't been there for a while. Oh, small claims.
In January of 2025, I told him I was not going to pay those 2 months of rent unless he came in and fixed my property. Because upon me moving into that property 2 years ago before that, he told me he was in the middle of remodeling the property and he would finish it. But during that time, do not interrupt me, Mr. Rhodes.
That was me.
No.
Where is the property?
It is on. It's in Three Rivers. It's I don't remember. 5887.
Please, I couldn't. I'm trying to figure out where this rental was.
It was on. It's at 58874 Ash Road.
58874. Is it a trailer or a house?
It's a house. It's a one-bedroom cabin, pretty much on the river, that Mr. Rhodes bought from the neighbor.
Who we bought it from doesn't know.
All right, I'm looking for the lease.
And then I could also tell you that. Okay.
Well,
is he wearing a hairnet?
That lease is null and void because we had a verbal lease the year before, 3 months prior.
I have a lease. So was there a lease?
In December of that previous year, before our Christmas break of 2024, we sat in his truck and agreed upon that he was going to come back and finish the remodel, and that we agreed that the lease was good for the next year. It was clearly stated by Mr. Rhodes, this lease is good for the next year.
All right. Well,
as long as I stay
somewhere a written lease.
No, it was done in his truck.
Is a verbal.
The only
lease.
Yes.
All right. What was the monthly rent?
$900.
It's not bad.
I refused to pay those 2 months of rent because I had no running water, no flushing toilet, and I had pretty much crap in my toilet, and I had a natural gas leaking into my place because he came into the house and pulled the pilot valve off and kept promising for a month that he was going to come out there and replace my stove, and didn't do it till after I'd already told him I was moving out.
Here it is, 58874 Ash Road. All right, this property couldn't be rented if it was in the city of Three Rivers. It wouldn't pass inspection, and this is very common. We have Mr. Cawthorn, you're making me dizzy. If you
sorry.
One spot. You're at work?
Yes.
And where do you work?
Same JRS with Mr. Rhodes.
What's the name of it?
Chair now. Jay Rettenmeyer, the mysterious German company you like to say.
Yes, that's mysterious. All right.
He's still moving around.
Okay. So there's no written lease. And what was the deal with utilities?
The reason why I did not pay the utilities is because I felt like it fell on Mr. Rhodes for putting the electric salamander under my house, knowing there was a running leak straight out the hot water heater that was cycling 24/7.
Electric
And he
salamander?
failed to do his job as a landlord and come fix the issues that he knew well enough about.
What is an electric salamander?
All right, so we got no lease, so we're on shaky ground right off the bat. No security deposit. There's something called the basic covenant of habitability, which he has to provide a premises that is habitable. If this premise was in the city of Three Rivers, they wouldn't have approved it for rental. And if the township knew there was no running water in there, they would have condemned it. How long did you have no running water?
Since right before Thanksgiving. He'd been out there like 3 times trying to fix it. He put in a new well pump. The well pump immediately broke. I ended up, after the power got turned off, I ended up having to buy myself a generator and all them things.
All right, well, again, how long were you without running water?
3 months before I moved out.
Right, so November, December, and January. When did you move out?
I moved out in, I moved out in April. I'd been dealing with this since November.
So you had no running water from November to April?
He would come in, fix it for 1 week, and then it would break again from November to January. And then that's when I looked at him and I said, hey, either fix it or you're not getting rent, because that is my right as a tenant to refuse rent until my property is fixed.
Well, there's a way to do it. So November and January. So then you were there February,
March, and I left at the beginning of April, the 1st.
Right. So did you pay any rent in February and March?
No. He got his last check in January.
So you didn't pay, you paid December and January's rent?
I'm pretty sure I only missed 2 payments altogether, and it was the last 2 months I was there.
All right, and the utilities do seem quite high. Now, once it got disconnected, you had to pay to get it reconnected, but the utilities are $1,350 from December 31 of 21 till I'm not sure when, 24 till I'm not sure when. That's pretty high. What was the story on the utilities, Mr. Rhodes?
All right, so as Mr. Cochran explained, there was a hot water leak that I was not aware of the climbing of the electric bill. And so by the time I found out about it, he had messaged me saying that it was unlawful to turn the electric off, which I never did. So by the time I was able to come out.
Let me back up. Did you turn the electric off?
No, I didn't. I did not. No, it's from not being paid. The AEP turned it off themselves.
All right.
The bill would go to to the address of Ash Road. And
well, the bill is in your name at Ash Road.
That is correct.
So you didn't turn it off, you just didn't pay the bill. It got turned
so if you didn't pay it and he didn't have any electric, that's on you. The bill's in your name, not his.
So real quick, there should be a copy of the lease in our paperwork. And in the lease, it is required that the renter was to put the utilities in his name, the natural gas and the electric.
Well, let me see. I couldn't find a lease.
It's going to be 11 pages. It probably back in with a file from March 5th when I filed the complaint to recover possession of property.
Oh, that's in the landlord-tenant case.
And then it's gonna be on,
all right, stop.
Yep.
You're not a very good landlord, Mr. Rhodes. You don't know what you're doing and you're in over your head and you're suing him for a bunch of money and you don't have a, all right, you said there was no lease. There is a lease, so let me see if I
he
can
didn't
find.
go 4 months without water though, Your Honor. He went at the most 3 days straight. After
All right.
the well pump froze up.
Let me see if I can find your other case, like a scavenger hunt here. You're the plaintiff. You have the burden of proving the case. And so one of the things you should have done is provided a copy of the lease. But let's see if we can find it.
And that was a lack of my knowledge.
Stop, I didn't ask you anything. Don't just start blurting things out. Wait a minute.
Apparently, more than one judge is not putting up with crap.
All right, that's 25521 LT. 25526 LT.
Sean's like, can you put that on the record, Judge?
All right,
He's a bad
let's take a
landlord.
look.
Judge has to access the other case to find the copy of the lease. Kimberly, it is Monday, definitely. Biggest problem I've had with our renters is they keep wanting to pay cash. They don't have to run to the bank. Chihuahua Mama.
Just to add to the sense of frustration, there's a terrible, that's not it. Annoying buzzing in here from a bad bearing and a fan. Let me look at this again.
That's like torture, Judge. I don't know how you could listen to that all day.
Two 5.526 LT. Yeah. Oh.
It was not stapled. It was not moldy, so I'm not complaining. We have the best renters ever. They're all traveling nurses, and they rent for 3 months.
All right, there is a summons and complaint. File number is 25526. It was filed in March. And you got the defendant's name misspelled as Cotherman, Sean Cotherman. Part of the reason why I couldn't find it, it's under Cotherman. Notice to quit was served in February. Defendant agreed to move by April 11th. And so, let me see if I can find the lease. All right, standard lease, January 1 of 23, Ethan Rhodes and Sean Cothern. From January 1st of 23 to March 31st, 23. After that, it becomes a month-to-month lease. Rent is $225 per week.
I thought he said $900 a month. So I guess that's sort of...
Which is different than $900 a month. $25 a month late fee.
If you got 4 weeks.
No security deposit.
Sean went back to work.
Landlord shall provide the following utilities and services to the home. Home repairs causing by natural age, furnace, water heater, well pump, sewage.
Okay.
It isn't clear. Are utilities beyond that? Home repairs caused by natural age, furnace, water heater, well pump, sewage. Doesn't have to do with about the electricity. So I got to go back to the other case that we're supposed to be in.
Apparently the ChatGPT
Page
lease.
9 of that lease, at the end where we sign it, there is a spot for the utilities of the tenant.
All right, well, let me go back to that.
California's like $900 a week. If you're lucky.
Maybe I didn't scroll down far enough. Here it is, additional terms and conditions. Tenant is to keep utilities active and paid. Also to internet is on them.
The TV and handwriting.
Is on them? That's the terminology.
Signed by Ethan Rhodes and Sean Cothern. Tenant is to keep utilities paid and also internet is on them. All right. So there's a lease which wasn't made part of this complaint, but I found it in another case. Established rent's $900 a month for this little place. No security deposit. So we got that. Utilities are somewhat unclear, but it says they're supposed to be there. So they're in your name. So you didn't pay the utilities and they shut his utilities off. How long were you out without utilities?
At least my last month there. I can't remember the exact amount.
That means no electricity.
Yes.
Now, despite what you said, the water wasn't out for months at a time. It was on and off sporadically, correctly?
It was literally, he would fix it, and then literally the next day it was broken again. So I have many witnesses that could attest to this too, because I did bring people over to see his handiwork and see that I had no power and water.
The trial is now.
Yeah.
So, all right. So no, from January to when you move. So the big question is, why the hell didn't you move out of there? You're in there in the middle of winter, no water, no heat.
Let me put this honestly. I'm not financially secure. Like I'm just now getting a pay raise where I can sustain where I live now. So I had to save up. That 2 months that he's asking for back is the only reason I was able to move out. I told him that I'm keeping the money, and because I don't have running water. I don't have running water. I had natural gas in my house.
Right. There's a way to do that, which is to pay the money into escrow, but I've only seen any do it right about once. So from January till April, how many days do you think you had no water?
Was that 90 days? I think I had running water in that 90 days, maybe 15 days of the 90 days.
And how many days were you without power?
The last month.
So from like March 15th to April 15th?
No, like March 1st to April 1st. I moved out April 1st. I started moving into my new apartment the 29th of March.
All right.
Because I had to get out of there because it was costing me too much. I bought I bought a gas powered generator so I could have power for me and my girlfriend.
You had a girlfriend in there with a toilet that didn't flush? Full of crap?
Yeah, you can't do that. That's a good way to get suffocated. All right. So The place was left in pretty bad shape, according to the photographs. And he claims several $100 in trips to the dump.
Which I have no problem paying a cleaning fee. I don't have any issue with that.
All right. Now, you also didn't pay the utilities, but you're saying he ran your utilities up by running electric equipment at your property, but yet he was trying to unthaw your pipes so you could have water.
Yes.
So he wasn't doing it maliciously. He was doing it to try to get power.
Yes, I do understand that, but during that time I ever lived there, the most my power bill ever got up to, and that it was like a 600 square foot house, was the max I ever had it at was $200 a month.
Okay. Mr. Rhodes, what else would you like me to know?
Well, I'd just like to contest about the 3 months with no water. That was false. He was true about having to go out every other day and restart the pump. It would trip out. But there was a space heater in the well room, the well house, that would keep the well house warm. But at the same time, it being an old house, a little crickety, because the first year we didn't have any problems. We got to leave the spigot on, just a little trickle of water so it doesn't freeze when it gets down to negative temperatures. The lines had froze. I come out, hook up a space heater that's ran by propane and just an extension cord to thaw the house out. As far as going without water for 3 months or even a total of the 15 days that he said, that's not true. The most he went was 3 days. I will admit that. I had a family emergency in Detroit when the pump froze from the well house freezing. Other than that, I mean, at any time he had a water issue, I was right out there that day when I got out of my normal working job. And
all right, so you're saying he wasn't 75 days with no water?
No.
He said it started before November, so it'd be more than that, like 100 or more days with no water.
No,
you disagree with that?
I do disagree with that. I will admit he would have to go out to the well house and reset the pressure switch to turn the pump back on, because I had issues with the water and the bladder tank I had to replace. I mean, it was always the work in progress. I never like shunned him or put him on the back burner. I mean, I was at my normal 8-hour job when I get out, acquired, and come out and work with him. And then there was a time he said that I was not allowed on the premises with him not being at home, so I'd have to wait till he gets out of work at 6 o'clock at night. We were always in agreement with everything. There was never no, like, well, it's going to be this way or it's going to be that way. It was, if you had an issue, okay, I got to work today, I'll be out there to address it. It was never like, I'm not coming, you have to go without. And same with electric bill, which I know I sent here, but I could always get the shut off notice, but he went 2 weeks most without any electric.
Okay.
But the bill was sent to the address.
I'm gonna split the rent in half, $900 for 1 month of rent. I'm gonna split the electric in half. It was quite a bit. Maybe I'll cut it in more than half. The electric was $1,800. He said it was $200 a month. That would be December to January to February to March to April, 4 months. I'll load $800 for electric. I will allow the entire cleanup cost. Keep losing my place, which is 340. That's $2,040, I think.
Bela Bird, happy birthday, and thanks for gifting a membership. Appreciate it. Glad we could sing to you.
It was $2,040. Plus the court costs of 86. 127.42.
Sean's not going to like this.
And $20, some sort of service fee, 106 plus 127.42. $133.42, $233.42. So it's a lot.
You're out of the country. I recognize you as being out of the country.
$2,273.42, which is a little more than half of what the plaintiff had asked for. All right, Mr. Cothran, can you pay some sort of monthly installment on that?
What would need to be the monthly installment?
I would ask for $150 per month.
Over the next 2 years.
Is that over a 2-year payment plan or no?
Yes.
When would the payments start?
October 15th.
When would they end? Sean, you're not in a position to bargain here.
Yeah, sure. Why not?
Well, you'd rather have that than have them garnish your wages. $150 per month starting October 15th.
I would.
Mr. Cothran, are you at Bacon Avenue?
Yes.
All right. Mr. Rhodes, you're still at Rock River Avenue?
Correct.
All right. Mr. Cothran, you had a question?
No, nothing. It's not important.
There's my finding. $2,040 for the plaintiff.
He's looking for a pen.
Court cost of $233.42 for a total of $2,273.42 payable at $150 per month starting October 15th. All right, you're both free to go. I'll send you a copy of that judgment. Make the payment directly to Mr. Rhodes at his address. My suggestion would you use a certified check or money order. All right.
I don't trust them. I'll send it and a copy.
All right, you're both good to go.
Sean's getting all lippy there. I love my grandkids.
Mr. Morton is here. Mr. Widener, is that you?
28 months.
I don't know who this telephone number is. Somebody logged in with a telephone number. I never was able to determine who it was. I
love being here with y'all. I love the straightforward family.
I'm not sure if you're speaking with me or not, but my name's Michael Morton. I had a court hearing scheduled with Sierra Diata today for a wage garnishment.
Oh.
Ooh, there's Geraldine Morton.
I didn't know who you
Michael
were.
Morton.
We'll come up with that one in a minute. Miss Morton, Mr.
Love my grandkids. Oh,
Mr.
28 months. Thank you so
Widener didn't show up for his own party.
Your lawyer? Your lawyer did it.
I was aware of this. Mr. Widener was over there on the River Road. The house was falling apart, and he claimed some story about he was going to pull the house off of there on a platform, or I never knew what it was, but he finally got removed from there by the township.
Yes.
Anyway, he isn't here, so I find default dismissal, plaintiff fails to appear. What's the status of this property now?
This is something completely different. So before Scott ended up over on River Road, I don't know if you remember last year, I incurred quite a few fines and fees, and it was due to, that was due to Mr. Widener. And then he moved the items that were on my property. Basically, I kept asking him to move, and he told me just put it on the street. So I did move it onto the street. I did not damage anything, but it wasn't even Scott's property. The stuff that he has listed in this lawsuit, the dog doesn't belong to him. The camper that he was suing me for does not belong to him. The food that he's saying he lost in the freezer, he was running an extension cord to my home, and I had unplugged it numerous times.
All right. Well, he isn't even here to argue about it, so the judgment is 0.
Yeah.
All right.
Yeah. But
are you
those
still
items,
on 12th? You're still on 12th Street?
Yes, sir.
All right. You're good to go.
All right. Thank you.
All right. All right, Mr. Morton, let's see what we can figure out. This is file number 28863SC. It's entitled Acre Mechanical versus Sierra Diata. The file number here, as I said, is 25863. Acre Mechanical, just a minute. Got a judgment against Miss Diata. And I think we determined, Kim helped me on this, the Diatas had declared bankruptcy, but prior to filing, so this service occurred after their bankruptcy. So, okay, that's what my recollection. So I entered the judgment. They had some other significant debts that were not satisfied, including a civil debt. I've got the wrong name down here for you, sir. What's your name, sir?
My name is Michael Morton, Morton.
What's your position with Acre Mechanical?
I'm the owner.
And you were here at the original case?
Yes,
all
sir.
right, let me make some notes here. I apologize. I didn't know who you were. All it was a
Uh-oh. Judge, you muted us. You set the books. You set the books on the mute. The caller has to say, I can't hear you. I can't hear you. Hello?
Mm-hmm.
Mm-hmm.
I don't know if you muted me.
Judge is just going on. He set all his books on the mute button. So it's just us and the caller. Maybe we should ask some questions. Right. Drive safe. Judge is waiting for the caller to respond. Caller's not responding. Can you read lips, caller? He's just on the phone. How long before he notices? I don't know. Caller needs to say, "Excuse me, Judge, if you're..."
It's just dead.
It's just dead. If you're talking to me, Judge, I can't hear you. Can we hear us now?
All right, I logged in early this morning and I just got logged out. It happens to me sometimes late in the day. Anyway, she isn't here, so she's in violation of the subpoena. I'm gonna do an order to show cause. Show cause why she did not appear.
We all log out late in the day. My whole family left.
For hearing. If she fails to appear for the order to show cause, I'm going to issue a warrant for her arrest.
That's a promise, not a threat.
Set a cash bond, which can be applied to the debt. That's the normal procedure in these discovery subpoena cases. She was personally served at her address on M66 where you did the work. She failed to appear pursuant to that subpoena, so she's arguably in contempt. We did the show cause first in case there was some emergency or some reason which would excuse their failure to appear. Absent that, and if she does not appear for that hearing, she can be put in jail. We don't have debtor's prison. You don't go to jail for not paying a civil debt. However, you can go to jail for contempt for failing to comply with a lawfully served subpoena. So that's what we're going to do. I don't know the date yet, but we will get a date for an order to show cause and compel her to be here. I guess Zoom will be acceptable, so you don't have to come.
Zoom's good for us, Judge. That works out. I'm good with that.
So we'll give you another date, and we will compel her to be here. If she isn't here, I could issue a warrant for her arrest. Hopefully she will come. She can answer your questions regarding your ability to collect on this debt. All right, Mr. Morton, I'm sorry it took us so long to get there. All it was there 49 minutes. Could have been worse. All right, sir.
Yes,
I will see you at the next date. Now, when you come, I would much prefer, in fact, I'm going to say this. If you can't log in by Zoom, you need to come here live. I don't want to do this by telephone. You're going to be in a discovery hearing with her. Well, I'm going to put you in a separate space, and you're going to ask her some questions about her ability to pay on this debt. It's very difficult to do it by telephone. So you either need to be here by Zoom or live. Telephone is not acceptable. Okay?
Okay. Arguably, Zoom is barely.
All right. Hopefully I'll see you by Zoom.
Yes, sir. I was able to do Zoom today. It just this was the procedure they gave us when my office lady called in. They gave her phone number and a message link. I have Zoom and cameras and everything.
Yeah,
I'm capable of doing
You
that.
did it by Zoom the first time. I'm not sure why they told you to call in. But Zoom is much preferable to telephone only. Like I said, I couldn't even tell who you were.
Yes, sir.
So, all right, next time we'll do Zoom. All right,
Yes,
sir,
sir.
you're good.
It's a plan, Judge. Thank you.
Thank you.
We do want the Zooms. We can't watch
All
if they
right.
don't film it.
That finishes what was a long day.
It was a long day, Judge.
And we got another long day tomorrow.
What's on the schedule?
But I signed up for this. So it's part of the territory.
Ran for attention.
Okay. Thank you all who are still here or watched any of this.
Yeah, you're welcome, Judge.
Ms. Diata, my suggestion is you contact Acre Mechanical to talk about setting a payment agreement. But otherwise, we're going to do a show cause, and if you don't come, you're going to get arrested, and nobody really wants that. All right.
Well,
that finishes our
one person.
day, I hope.
Yep. And he's done. He's done, just like that. Judge comments are always brilliant. It is 4 o'clock. It went quickly. Today. Why did this not work on that front? Okay, there we go. It's 4 o'clock, which is pretty quick. At the end of the day, my wife and her offspring, my offspring, we're our offspring. I guess we could take joint credit for that. Left. I don't know where they went, but my wife called me on the second oldest phone and said, "Hey, we're all gone. Just so you know, you've got one son still there." I went out and checked him and said, "Hey, you still here?" He's like, "Yeah, but I'm leaving in 20 minutes, going to work." I'm like, "All right." And then he just said, headed to work. So now I'm all by myself. There's nothing to do. It's awfully quiet. But that being said, I think I can figure something out. So, Mimi, thank you very much. This is a fun little place to work and play. I have to fix this. I don't know how to do it, but oops, that's my phone falling over. Right here, I've got a little extra thing that I need to move and position right. It's never in the right spot. I got this rack to support my replay machine, so I can rewind and play and all that. I just can't get it mounted in a way that I like yet, so we're still working on that. I'm full on home alone. How did the yard work go? Yard work was great. For those that don't know, I did go to the Collards Festival. I did, on impulse, enter the collard eating contest. I think I made a respectable showing in that, considering that I do not like collard greens. I ate over 3 pints of them. The winner ate over 6. So, I mean, that's not bad. I did surpass, I believe, all the female contestants on how much they ate, which just means that women are smarter than men. That's all that shows. But yeah, I did not win the contest. The collards were made at a restaurant, I kid you not, called Bum's Restaurant. And over 45 pints of collards were consumed by those of us who competed in the contest. I didn't know till afterwards. I guess collards are expensive. They must be, because the restaurant, when the contest was over, the 30-minute eating contest was over, they announced that all the leftover pints of collards would be sold for $10 per pint. Like $10. I ate $30 worth of collards? I guess 40. I pretty much wasted the one I started eating. No one's going to want to buy that one, half-eaten collards. But anyway, yes, if there's something you can put on collards to make them taste something other than like lawn clippings, please let me know. I did not have that with me. I was at a serious disadvantage. I did find a little chili. It was like a vinegar bottle with the peppers in it. Whatever that is. I dumped that on so I could at least get some heat. But I tried the vinegar. That was not feeling it. Not feeling it. Butter and salt. I didn't find out till afterwards that I could have asked for cornbread, which could have at least given me a switch to a different flavor occasionally. So anyway, that is the Southern way. I tried. You can the town can stop bugging me about participating in festivities, because how many people can say they can participate in the collard eating contest? I did. Got lots of viewers that way. All right. We're going to wrap it up for today. It's only 4 o'clock, but that gives us a little bit of time to, do some other stuff. We're working on a couple things on the channel, and so we'll keep you updated with that as we move along that way. And I think I've got some homework to do for Weather Watch as well, if he's assigned it to me yet. So let's see. Maybe. Not sure. Okay, that's not it. Gonna go with soul food tonight. Collard greens sounds so amazing. Red Pen. More power to you. I'm not going to fight you for the collard greens. I'm probably not going to have collard greens again in my life, honestly. If I had a meal served, if somebody serves me some barbecue, like Southern barbecue, we're talking pulled pork with vinegar and some hush puppies and, all that, and there's a side of collard greens, I might eat it. But if it's more than 2-3 forkfuls, I'm done. I'm not doing any more. All right. Today was a Monday. It has flown by. It has. Hope your day also went quickly. So play the music, please, says Carol. Play the music. I'll play the music. Collards are best as a side. I agree. I mean, it just gives you some contrast. It's like, here's some good-looking food, and then we have the collards over here. But everybody, even if you like collards, you look at them, it's like, that does not look good. Like, if I saw that just like out of the blue, I'm like, oh, what happened? That's my go-to. So their season. Mine were not. Mine were pretty much just straight collards. I don't know. Maybe with Mrs. Oregon, I can go have some Chinese or something. No, all my cars are gone. I don't have a car. I have to order it here. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning, bright and early, 8:30, 8:45, maybe as late as 9. We are keeping our ear to the ground and our eyes peeled to look for a new court case we can follow together and enjoy together. Signing my shirt. What are you making me? I was already planning to be your corporate sponsor in next year's competition. Maybe you could be my representative, Graders. I'll figure it out. After all the collards, you're lucky to have a new bathroom. Won't talk about that. It's a family show. Going to have to confess, I just had to Google what collard greens are, and I'm guessing they're not a UK thing. No. I think the closest thing you've got, Ali G, would probably be Brussels sprouts, only I like Brussels sprouts. So, I don't know. You guys be good to each other. We will see you in the morning. Have a good night. Bye-bye.
It's bigger than you. It's bigger than me. It's bigger than all of us.
I saw a chicken fly.
Hush! Now I'm trying to have court. You don't raise your voice again.